Okay, for this video, I'll be discussing arraignment. So, what is arraignment or what is the nature of arraignment? Well, arraignment refers to the stage where where the issue are joined or combined in criminal action, without which the proceedings cannot advance further or if held will otherwise be void. So, importante talaga yung arraignment. Bakit? Ang issue dito ay i-join or combine. Okay? Kaya anong issue ba? Ano bang kaso? And the proceedings cannot advance further without arraignment. Otherwise, it will be void. Okay? So, mandatory talaga ang arraignment in a criminal cases. Now, it is a stage where the accused is formally informed of the charges against him done in open court and asking him whether he pleads guilty or not guilty. So again, no, mandatory arraignment, importante ang arraignment. Bakit? This is the time when the accused is formally informed of the charges against him. Okay, formally informed of charges against him and as is being asked whether he pleads guilty or not guilty. Okay? Now, according to Atty. Gabaw, it is a mode of implementing the constitutional right to be informed of the nature and of the accusation against him. Kasi isa sa constitutional right na accused ay the right to be informed of the nature and cause of accusation against him. And to fix the identity of the accused, that is done during arraignment. That is done during arraignment. So, basically, the purpose of arraignment is to hear formal information, babasahin or inform siya sa formal information or indictment niya or charge niya, and allow defendant to enter a plea, whether it is a guilty plea, not guilty plea, or guilty to a lesser offense. Now, plea refers to defendant's answer. Ito yung answer ng accused to a criminal charge, whether guilty or not guilty. And we have some rules on arraignment. Trial in absentia is allowed only after arraignment. So, in my next videos, I will discuss the relationship of trial in absentia and arraignment. But basic concept here is that you cannot conduct trial in absentia if hindi pa na-arraign yung accused. Kailangan muna ng arraignment before ang court mag-conduct ng trial in absentia. And judgment is generally void if the accused has not been arraigned. So, importante, kahit na may judgment na, may decision na, if hindi pa siya na-arraign, then the judgment is void. Kasi nga, hindi siya na-inform sa nature and cause of accusation. Now, there can be no arraignment in absentia. No? Pwede ba yung arraignment na wala yung akusado? The accused is absent? Yun yung ibig sabihin ng absensya. The accused is absent. General rule, no. Hindi talaga. There can be no arraignment in absentia. Hindi pwedeng hindi darating yung accused during arraignment. Kasi kung wala ang accused during arraignment, walang mangyayaring arraignment. Siya yung superstar dyan, no, during arraignment. Kaya in this example, no, Laila de Lima dumating sa Muntinlupa RTC para sa kanyang arraignment. Importante nandun siya sa kanyang arraignment. Kasi siya ngayong tatanungin, siya yung inform sa kaso niya at tatanungin siya what is his plea, guilty or not guilty. Now, procedure of arraignment and plea. Arraignment shall be made in open court by a judge or clerk by furnishing the accused of the copy of the complaint or information, reading the same in a language or dialect known to him, and asking him whether he pleads guilty or not guilty. So, tatlong bagay ang mangyayari during arraignment. One is furnishing. Furnishing is giving of copy. Furnishing is giving of copy of the complete information. Bibigyan siya ng copy ng complete information. Reading, babasahin yung complete and information in a dialect known to him. Kaya kailangan yung interpreter during arraignment. No? Kung no-read yung accused, or Chinese yung accused, Korean ba yung accused, no? Kailangan ng interpreter. And asking him whether he pleads guilty or not guilty. So basically, ito yung FRA, furnishing, reading, and asking. And the accused must be present, doon kanina, kailangan nandun ang accused during arraignment, and must personally enter his plea. So, hindi pwede yung abogado mag-enter ng plea. Hindi pwede sabihin ng abogado, Your Honor, in behalf of my client, I am entering a not guilty plea. Hindi pwede yun. It must be the accused who should personally enter his plea. Now, so, ito, example, this is during arraignment. Ano mangyayari dyan? Tatlo, FRA, furnishing, accused copy of the complete information, reading, okay, babasahin, and the information in the language dialect known to him, and asking him whether he pleads guilty or not guilty. Okay? So, FRA. Now, when the accused refuses to plea or makes a conditional plea, a plea of not guilty shall be entered for him. So, what if, tinanong siya, what is your plea? Hindi sumagot. Refuses to enter plea. Hindi sumagot. Invoke niya yung kanyang right to remain silent. Or he makes a conditional plea. Sabi niya, Your Honor, guilty ako niyan pero hindi murder, homicide lang. Your Honor, guilty ako niyan pero hindi rape, acts of lascivious business lang. Okay? So, anong gagawin ng court? The court will enter a not guilty plea in behalf of the accused. Kasi ayaw mag-enter ng plea. Okay? Now, when the accused pleads guilty but presents exculpatory evidence, anong exculpatory evidence? Ito yung mga justifying or extenuating circumstance like self-defense, defense of stranger, defense of relatives, minority, imbecility, insanity. His plea shall be withdrawn. I-withdraw yung plea of guilt niya, and a plea of not guilty shall be entered for him. Kasi he presents exculpatory evidence. Okay? Example, Sandigan Bayan naghain ng not guilty plea para kay Senator Enrile na tumangging magpasok ng tugon. Answer. Tugon is answer. Kaya what is your plea? Ayaw magsalita ng Enrile. Kaya ang Sandigan Bayan mismo, yung court na mismo, ang naghain ng not guilty para sa kanya. Okay? He refuses to make plea or silent. Hindi sumagot during arraignment. Dines Correo, nabasahan ng sakdal. So means that's arraignment. Nabasahan ng sakdal sa arraignment. Korte naghain ng not guilty plea. Korte naghain ng not guilty para kay Correo. Again, it's the court that enters a not guilty plea para kay Dines Correo. Kasi ayaw niyang sumagot during arraignment. Now, the accused shall be arraigned within 10 days from the date of raffle, and pre-trial conference of his case shall be held within 10 days after arraignment. So, kasi yung case, pag ma-arrest na yung tao, i-raffle yan. Kaninong branch yan? Branch 1 ba? Branch 2? Branch 3? Then, after ma-raffle, 10 days, kailangan ma-arraign na siya. And pre-trial conference of this case shall be held within 10 days after arraignment. So, pre-trial conference 10 days after arraignment. Now, in case the failure of the offended party to appear despite due notice, the court may allow the accused to enter a plea of guilty to lesser offense, which is necessary included in the offense charge, with the conformity of trial prosecutor alone. Kasi ganito yan. Audit during arraignment. And the accused is charged with murder. Okay? Tapos sabi ng court or sabi ng judge, what is your plea? Your Honor, I would like to plead guilty to a lesser offense of homicide. Okay. So, normally, kaninong consent para malaw yung plea of guilty to lesser offense? Kailangan consent ng prosecutor at saka ng offended party. But in case the offended party is not present during arraignment, during arraignment, wala yung offended party, now, pwedeng i-allow ang plea of guilty to a lesser offense with the conformity or consent lang ng trial prosecutor. Pwede yun. Kasi wala yung offended party during arraignment. Kaya importante, if you are the offended party, nandun ka during arraignment. Para yung maka-object ka just in case ayaw mo. Now, arraignment shall be done within 30 days from the date the court acquired jurisdiction over the person of the accused. Anong ibig sabihin ng the court acquired jurisdiction over the person of the accused? Ito yung arrest. The moment the person is arrested by virtue of warrant, kailangan siyang i-arraign within 30 days. Okay, let's have an illustration. arrest, no? Arestado yung tao, yung akusado or yung suspect, no? Arestado. Now, after arrest, when we see arrest, no, the court acquired jurisdiction over the person of the accused. Kung ano yung jurisdiction. So, pwedeng may raffle, i-raffle yan, kaninong branch, kaninong sala, branch 1, branch 2, branch 3, branch 4. Tapos, after 10 days after raffle, kailangan ma-arraign. But in no case shall arraignment be more than 30 days from arrest. So, from arrest, kailangan 30 days na arraign na siya. Kasi pag hindi siya ma-arraign within 30 days o 1 year na, arestado 1 year, wala pang arraignment, pwede siya makapile ng motion to dismiss on what ground? Violation of his right to speedy trial. Okay. Arraignment. Offended party is present. Nandun yung offended party. Yung biktima nandun. Or just in case, offended party is not present. Hindi absent yung offended party, yung biktima. Now, what if the accused enters a plea of guilt to a lesser offense? Plea of guilty to a lesser offense. Okay. Kaninong consent ang kailangan? The court may allow the plea with the consent of the prosecutor or offended party. Kasi present siya. Present siya. Pero what if absent yung offended party and the accused wants to enter a guilty plea to a lesser offense? The court may allow the plea with the consent of prosecutor alone. Kasi wala yung offended party. Now, the restoration. Duplemengo was charged with 2 counts of raping his daughter. Upon arraignment, Duplemengo pleaded guilty but bargained for lesser penalty for each case. Complainant's mother and a public prosecutor agreed with the plea bargain. Hence, the trial court rendered judgment sentencing Duplemengo to 10 years for each count. Was there a proper plea bargaining? Remember, ang kaso niya is rape. And ang binagi niya, okay, mag-plea guilty ako sa rape pero kailangan i-bargain ko yung lesser penalty. Pwede bang i-bargain ang penalty? No. The general rule is hindi mo pwedeng i-bargain ang penalty. Ano pwede mong i-bargain? Yung rape case. Itong rape case pwedeng ibaba sa actual lasciviousness or attempted rape lang. Okay? But you cannot bargain the penalty. Okay? Dito kayo malito. Was there a proper plea bargaining? The answer is no. Plea bargaining was not proper. The accused did not bargain for lesser offense. Hindi siya nag-bargain for lesser offense. But pleaded guilty for rape and bargain for lesser penalty. Hindi pwede. Ang pwede mong i-bargain is yung lesser offense but hindi pwede yung lesser penalty. That's people who's maga. The accused pleaded guilty to homicide. Allowed to prove mitigating circumstances. Nag-plead guilty ng homicide, pagpatay. The accused instead testified that he acted in self-defense. So that's exculpatory evidence. No plea of not guilty was entered for the accused. So was the plea proper? Nagpresent siya ng exculpatory evidence? No. The plea is not proper. When the accused pleads guilty but presents exculpatory evidence, his plea shall be then withdrawn, i-withdraw yun, and a plea of not guilty shall be entered for him. Now, grounds for suspension of arraignment. Kailan ba masususpend ang arraignment? Okay? Hindi niya maka-cancel, no? Suspension lang. Number 1, ground for suspension of arraignment. The accused appears to be suffering from unsound mental condition, which effectively renders him unable to fully understand the charge against him. So, unsound mental condition, hindi matinong kausap. For example, ganito. Tinanong sa court, how do you plead? He, ako budoy. Oh, yan yung sabi niya. Oh, he, ako budoy. So, that's unsound mental condition. Ano mangyayari sa plea? The plea will be suspended. The arraignment shall be suspended. There exists prejudicial question. Okay? May previous question pa na may motion na kailangang i-resolve. Or there is petition for review before the Secretary of Justice. Okay? Petition for review before the DOJ Secretary or Office of the President. But it shall not exceed 60 days count from the filing of petition. So, tuloy ito. Court postpones na police arraignment. Bakit pinospone ng korte ang arraignment na police? Okay? The police facing charges of illegal detention was scheduled on arraignment on Monday, but her lawyer argued court should deliberate first on pending motions. May pending motions na o bill of particulars Okay, bill of particulars and to suspend the proceeding. So, dahil sa motion na bill of particulars, pinospone, that's prejudicial question. Pinospone mo na yung arraignment. Ito, DOJ barred from resolving petition for review. Ito naman yung petition for review, no? Ng Secretary of Justice. Now, pwede ba matuloy ang arraignment kung may petition for review? Hindi. Actually, this is Mario Joel Cruz Reyes. Ito yung dating governor ng Palawan. Ito Mario T. Reyes, dating mayor ng Coron, Palawan. They were accused of killing, murder of Doc Jerry Ortega sa Palawan. And i-array na sana sila, pero may petition for review before DOJ Secretary, kaya pinospone yung arraignment. Bill of particulars. The accused may, before arraignment, move for bill of particulars to enable him to properly plea or to prepare for trial. So, bill of particulars is specific. You want to specify. If the information or complaint is defective or ambiguous, masyadong hindi malinaw or hindi malinaw yung complete information, gusto mong ma-specify, mas madetalyado yung information complaint, pwede ka mag-file ng bill of particulars or you want to specify it. For what purpose? To enable him to properly plea and to prepare for trial. Okay? So, I think I have example yan. Supreme Court, SC, grants and really motion for bill of particulars. Motion for bill of particulars. Bakit? A bill of particulars is filed to make allegation more specific. Kasi gusto, medyo hindi malinaw, malabo yung yung nakalagay sa information complaint. We want it to be more specific. It is filed if defendant in criminal case believes he is not sufficiently informed of the crime which he is charged and not in possession to defend himself or properly adequate manner. So, I think that's the last part of my discussion on arraignment.